All right. I think people are going to roll in, but I might as well get started, I guess. Yeah, so we got about 33 people on the call, so I'll launch. Hi, everyone. Thanks so much for joining us for Pandem-ocracy, Voting Rights and Access During the COVID Crisis. I'm Danielle Strollo, Events Chair for the University of Idaho's ACS Student Chapter. This is our first virtual event, so thank you all for being a part of it. And thanks also to the ACS Madison chapter and ACS at-large chapter for co-sponsoring and helping us put this event together today. I'm really excited to hear from some of the country's foremost election law experts and scholars about what happened in Wisconsin a mere 3 weeks ago. I know it feels like an eternity ago, to me at least, but it was only 23 days ago. So let me just take a few moments to introduce our panel members, and then I'll toss it over to Professor Cover to explain the format and kick it off. First, and I'm going in no particular order here, we have Professor Atiba Ellis, Professor of Law at Marquette University in Milwaukee, Wisconsin. Professor Ellis's research is focused on voting rights law with specific attention to how varying conceptions of the right to vote exclude voters on the margins. He has written about the economic entry barriers posed by voter ID laws, felon disenfranchisement laws, the theoretical effects of the Citizens United Supreme Court decision, the impact of the Supreme Court's decision in Shelby County v. Holder, and related topics. His current research focuses on voting rights theory and how ideology affects the scope of the right to vote. Next, joining us from sunny California is Professor Juanita Tolson, Professor of Law at USC's Gould School of Law. Professor Tolson's scholarship and teaching are focused on the areas of election law, constitutional law, legal history, and employment discrimination. She's written on a wide range of topics, including partisan gerrymandering, campaign finance reform, the Elections Clause, the Voting Rights Act of 1965, and the 14th and 15th Amendments. Her forthcoming book, In Congress We Trust, The Evolution of Federal Voting Rights Enforcement from the Founding to the Present, will be published in 2020 by Cambridge University Press. Before joining the USC Gould faculty, Professor Tolson was the Betty T. Ferguson Professor of Voting Rights at Florida State University College of Law. Third, also hailing from Wisconsin, is Jeffrey Mandel, a litigator with the firm Stafford Rosenbaum in Madison, where he co-chairs Stafford Rosenbaum's litigation and appellate practice groups. Between November 2018 and October 2019, Jeff argued 4 cases before the Wisconsin Supreme Court, more than any other private practice lawyer in Wisconsin. Among those cases was a procedural challenge to the constitutionality of the Wisconsin legislature's lame duck extraordinary session in December 2018. In addition to his Wisconsin litigation experience, Jeff has also represented numerous amici before the U.S. Supreme Court, including in Murray, Wisconsin, where he represented the Wisconsin Counties Association, the Wisconsin Towns Association, and the League of Wisconsin Municipalities. He also represents businesses and individuals in disputes involving contracts, torts, property, administrative law, statutory construction, bankruptcy, election and voting law, and intellectual property, as well as novel questions of state and federal constitutional law. And finally, I will introduce our panel moderator, the University of Idaho College of Law's own Benjamin Plenner Cover. Professor Cover is an election law specialist whose work on the petition clause and partisan gerrymandering has appeared in the Stanford Law Review and the UC Davis Law Review. He has served as a peer reviewer for the Election Law Journal and currently serves on the executive committee of the election law section of the American Association of Law Schools. His article on partisan gerrymandering was recently cited by a federal 3-judge panel in the case of Ohio Philip Randolph Institution v. Householder in the Southern District of Ohio, decided in May 2019. He started as a visiting professor here at U of I in 2014 and has been tenure track since 2017. And if you're here at the University of Idaho, this fall would be an epic time to take his election law class. So thank you for all for joining us. With that said, I'll turn it over to Professor Cover to kick off our panel.
Thank you very much, Danielle. Thank you for the plug for this fall's election law seminar. Thanks to all who put this together. This is a very timely discussion. We want to dive right in, and so I'm going to invite Jeff Mandel to provide a brief background on just what exactly happened in Wisconsin a few weeks ago, some of the key issues and litigation. And then I will just get things started by posing a couple questions to the panel, and we'll just take it from there. I do want to note that we have the private chat function on Zoom, and so if any of the attendees have a question that they would like to be posed to the panel, You can send that question to me via private chat, and I will try to incorporate that into the discussion as we go. And so with that, I'll turn it over to Jeff Mandel and ask the question, what happened in Wisconsin?
Well, thanks, Benji, and thank you all for having me. It is hard to believe, Danielle, that it's only been 3 weeks. So much has happened both on the election law front and, here in Wisconsin, we're busy. The legislature is now sued to set aside the public health orders for COVID-19. And a lot of us have been briefing that this week. But what happened in Wisconsin was a bit of a mess. We had our presidential primary and our annual spring election set for April 7th. As the COVID-19 crisis picked up and more states moved their presidential primaries, we wound up in a position where Wisconsin was the only state that still had a vote set in April. And lots of people around the country thought that this was insane and we were simply being stubborn and that the vote should have been moved. But I think what is important to recognize is that what we were holding here in Wisconsin was a lot more than just a presidential preference primary. There were approximately 3,600 other matters on the ballot around the state for judges, for mayors, for county commissions, school boards, referenda, and a lot of those offices turn over very, very quickly. Many of the local and county officials who were elected on April 7th have already taken office. And I think there was a real concern, both on the governor's part and on the part of others, that if the election was not held as scheduled, we could have paralysis in our local government at a time when, in the midst of a pandemic, that was a really inauspicious time for local government to stop working. So there was a bit of a showdown because the election statutes are highly specific and very detailed and are controlled by the legislature. The legislature had adjourned its regular session for the year and was not planning to come back and was not interested in coming back to deal with the election. The legislature took the position that the election should simply go forward and everything would be fine. The State Elections Commission, which is a bipartisan body that exists to help oversee how our elections work and to provide guidance to local and county election officials around the state, took the position it did not have the power to move the election or do anything else to change state law. And what we wound up with was a whole panoply of litigation. There were 8 cases, 6 filed in federal court, 2 filed in the state Supreme Court. 3 of those cases in the Western District of Wisconsin in the federal courts were consolidated and went on to the 7th Circuit and then the U.S. Supreme Court the evening before the election, as many of you know, and we can talk about what those cases did accomplish, what they didn't accomplish, and what people are still trying to do.
Benji, you have to unmute yourself.
Okay, thank you. And thanks, Jeff. So 2 of the most important decisions one was a decision by the Wisconsin Supreme Court that the governor did not have authority to use emergency powers to postpone the election. And then the other decision was that the U.S. Supreme Court intervened to significantly limit an injunction ordered by the federal district court to try to make it easier for people to vote. Did these courts make the right decision? Was it appropriate for the U.S. Supreme Court to intervene at all? And what did these 2 decisions suggest to us about what might happen if there's litigation related to the presidential election in November?
I'm happy to jump in here because I actually want to get Jeff's thoughts since he's like on the ground about some of my concerns about the Supreme Court decision. It seems to me that the court was concerned about the district court order in part because it made provisions where absentee ballots postmarked after Election Day would still be counted, And so that seemed to be their core concern. And they sort of viewed that as a post-election change in violation of what election law scholars call the Purcell Principle, which cautions against last-minute changes to the election. And so the district court order, by crafting an order that allowed certain ballots postmarked after election day to count towards the election, they viewed that as a change in the election procedure. But so I think intellectually I understand that. But I think one of the things that troubled me about the Supreme Court decision was the fact that a lot of Wisconsin voters had requested absentee ballots but never received them. And it was a fair amount of Wisconsin voters who made those requests, but there was there was really no mention of them in the U.S. Supreme Court opinion. And not only that, there were various points of the U.S. Supreme Court opinion where they're proceeding as if this is an ordinary election, right? This is a time where we are dealing with a once-in-a-century pandemic, right? But if you read the U.S. Supreme Court opinion, it doesn't seem that they take that into consideration. And so I think my primary concern was that the court was insufficiently attentive to the fact that a lot of Wisconsin voters had actually did what they were supposed to do, right? They requested absentee ballots. They never received them. And then the U.S. Supreme Court decision made it so that they have to actually go out and put their health at risk to turn out to vote on election day. And I think that is my primary concern. And if you look at the case law, there's a right to vote that the court has inferred from the U.S. Constitution, right? And so when we think about these public health concerns, we also have to think about the fact that the right to vote is supposedly fundamental and it counts for something. But if you read the Supreme Court's opinion, it seems like they're more concerned about being formalistic under the assumption that this is a normal election when it's anything but. So I'll stop my rant and sort of pitch it back to my co-panelists.
Atiba?
Well, I'm going to tag team with Fernita there, and because my rant in particular, I mean, joining everything Fernita said, I think that's right, that the voters were absent in the Supreme Court majority's analysis. And I also think that this sort of strict formalism that Fernita's talking about also infects the Wisconsin Supreme Court's analysis, right? They, in a very shallow manner, in my view, basically said the governor does not have the power under the state constitution or his emergency powers under the general statutes to postpone the election. And it seemed to me that that was thin too, and that there was little concern for the voter there. And so there's that to be thrown in the mix. But I think even in thinking about what the Supreme Court did under what we call the Purcell Principle, that in a way the Supreme Court, I mean, Rick Hazen has argued that the Supreme Court has always treated Purcell as sort in an incomplete way. And to me, the underlying concern, which points to like the Anderson Burdick kind of analysis, where we actually have to stop and balance the interest of the voters and against the interest of the state in making any decision, which would speak to a broader conception in terms of what the Supreme Court of the United States did, and sort of saying, well, what are the factors for assessing an injunction? It's not just, is it too close to an election for there to be confusion? I mean, Hazen argues that that has to be folded into a broader analysis of, is there likelihood on the merits? Is there competing interests of the parties that have to be weighed? And is there a public interest question? None of those things were asked. And it seems to me that those things should have been asked by both courts. That's my rant.
I agree completely. And I just want to piggyback on Atiba's point, because one other thing that struck me about all of this is that these states are not learning from each other. We just went through something similar in Ohio. I mean, hello, wake up, right? The fact that Ohio had a very similar issue about whether or not to cancel or postpone its primary. And you had this, you know, the governor of that state trying to take steps that were potentially problematic. And then the public health officer of the state having to step in and actually say, look, we're closing all of the voting places. Why didn't Wisconsin look at that controversy and say, okay, we can learn from this? Instead, you had this, mess between the governor and the state legislature and the courts. And, it just turned into this huge debacle, in part because states are not learning from each other. And it honestly makes me afraid about what we'll see in June.
Well, I second that fear, Fernita. Let me just quickly say that I served as special counsel to the governor on some of these election issues, and I just want to be clear that my views today are my own, and I'm not speaking on behalf of the governor or anybody else in the administration. And I'm also going to try to be real careful not to share things that were between me and people on that team. But what I would say in terms of your last question, Fernita, why aren't we learning from each other, is a really important question. But as I mentioned earlier, the election here in Wisconsin was materially different than the election in Ohio because we did have all of these other concerns. And then the other issue is, I think we are learning, or we're trying to learn, but state statutes are also very different. So, I don't know exactly what the Ohio statute says. I know that the court there found the governor didn't have the authority and they had to go through the public health officer. But here in Wisconsin, the statute is actually pretty clear and pretty strong. The statute, and I'm talking about the statute on the governor's emergency powers. It says that the governor has the authority to make any order that he deems necessary to protect public security or property. I mean, public security, that's health. And so I think that many people, myself personally included, felt that the governor was in pretty strong stead when, after having given ample time for more than a handful of different federal court challenges to work their way through and see what was going to happen there, after having given ample time for the legislature to come in and take action, and then expressly calling the legislature back into a special session under his constitutional authority to do so, to have them deal with the election, and only to be met with a complete shrug of them gaveling the session in and gaveling it out without anyone actually attending. There were only 2 people in the legislative chambers. They just used the clerk to gavel it in and say, we're not interested, and gavel it back out. So the governor, I think, feeling that there were no additional options at that point, did issue an executive order under that statutory power that I mentioned before. The question is not only why aren't the relevant political actors learning from each other, but what are the courts in these different states learning from each other? Because that might be an even more dangerous question in some sense. And I would suggest that courts around the country should be very wary of looking to the Wisconsin Supreme Court, especially as a model of good jurisprudence at this point. When the legislature filed that lawsuit, they filed it as an original action starting in the Wisconsin Supreme Court, right? So no fact finding. And that lawsuit was filed at approximately 2:20 in the afternoon. At 3:15 in the afternoon, the court issued a scheduling order that gave the governor 15 minutes to file a merits brief. 15 minutes. And when the governor filed his brief, and to the court's credit, they accepted it 3 minutes late. It went in at 3:33 and they accepted it. It was 39 pages long, and it took only an hour and 4 minutes for the court to issue an order saying that the governor was wrong and that his order was enjoined. How does a court of 6 people who aren't all in the same place because of the pandemic read, digest, consider, discuss, decide, and then write an order in 65 minutes? It just doesn't feel like the court is engaged in the kind of deliberative process that A, we want from our courts, and B, that this vital right of voting in our democracy deserves.
So I have a question thinking about November, and I'm thinking about, in Bush v. Gore, Rehnquist, Scalia, and Thomas signed on to this concurring opinion, talking about the independent state legislature doctrine and the idea that each state legislature gets to choose how to run the presidential election, and it's the legislature specifically. And that if any other state actor, like the Florida Supreme Court, was not faithfully just interpreting the law, but actually making up law or changing the law passed by the Florida legislature, then that would create a federal constitutional problem. If this had happened in November and the Wisconsin Supreme Court had gone the other way and said, yeah, you know what, the governor does have this very broad emergency power to just change election rules, do you think that the currently composed U.S. Supreme Court that there might be a majority on the currently composed U.S. Supreme Court to say that violates the federal Constitution? And that the decision that we need to follow state statutes, and that we can't have either governors suspending statutes pursuant to emergency powers or courts using equitable powers to change statutes?
I don't think that the court would sign off on that, the U.S. Supreme Court, in part because there's this concern in Bush versus Gore about the federal interest. Right, because when Bush versus Gore was being litigated, there was a lot of concern by supporters of President Bush and those involved in the case that, you know, that this is federalism, right? That each state sort of decides how to run its, you know, its small part of the presidential election. And, you know, why should the U.S. Supreme Court become involved in that? But the Supreme Court emphasized that very federal interest in stepping in and stopping the Florida Supreme Court from interpreting state law in a way that they felt was inconsistent with the spirit of Article 2. And so I could easily see them making the same argument in the context of the Wisconsin governor coming in and basically using his authority to change the election in a way that they view is in contravention to the Wisconsin statutes, or that otherwise undermines the federal election. So I do think that there's a weighty federal interest there that the court will put a lot of weight on in order to justify their intervention.
Yeah, I mean, I think that things would be a little bit different because you'd have federal things on the, you know, you'd have a federal election on the ballot, and you also have calendar obligations with regard to the Electoral College and so forth. You know, to me, the question that is raised by this conversation, Benji, is there something special and unique about election administration statutes? Are they some kind of super statutes that can't be touched in ways that others can? I mean, if we're talking about what emergency powers a governor has, whether we're talking about Wisconsin or elsewhere, and those emergency powers are set by their own statute, why it would seem odd to me to just automatically assume that the election statutes somehow trump or are immune from whatever processes those emergency statutes set forth.
Jeff, I think that that's an excellent point. I do think they're special. Yeah. I think they're special, right? I never thought about it like that, but I do think they're special. Because they, just by virtue of their incorporation into Article 2, right? The fact that state legislatures are charged with discharging, you know, the presidential election, I think that does make them special. And so it's both good and bad and the implications of that, right? And sort of how the Supreme Court treats state authority in this context. And it almost seems like the usual rules don't apply.
Well, that's super interesting. And the practical question that I have about that, Pranita, is, you know, goes back to what you asked before about the postmarks. If it is the case that election statutes are special somehow, should we be worried about the fact that they can be changed through ordinary bicameralism and presentment, like regular statutes? And the reason that ties into the postmark question you asked before is you correctly noted that one of the things that concerned the U.S. Supreme Court was that District Judge Conley here in Madison had said that he would allow ballots, mail-in absentee ballots, to be counted if they came in within a certain number of days after the election. Mm-hmm. And one could say, and the Supreme Court did say, that deviates from Wisconsin statute and therefore it's wrong. But one could also say, and I think this informed Judge Conley's view, certainly is something some of the advocates pointed out to him, that until a couple of years ago, that was the Wisconsin statute. Mm-hmm. And so this was a modification and a accommodation to extraordinary circumstances, as you talked about, that was not particularly insane or unprecedented, because this was something that had served the state well for many decades. But you can see that that's a double-edged sword. On the one hand, the legislature changed the law. On the other hand, should we treat as some kind of super special statute that courts can't touch a law that the legislature can pretty much change whenever it wants, just through any other legislative process?
And to that point, it does also bring to mind the fact how much norms inform all of this, right? So it's funny that that was Wisconsin law up until 2 years ago, because after the U.S. Supreme Court decision came out in RNC versus DNC, you saw a lot of people making the point that our norm is that votes counted after election day, votes cast after election day don't count. Everybody talked about that as a norm. And I find it incredible that that was actually the rule in Wisconsin until 2 years ago, so fairly recently. And so to the extent that our norms about how elections work and how we count ballots inform whether or not a particular remedy is appropriate, I do think recent history matters, right? But also a double-edged sword. Interestingly enough, and I'll just mention this because I don't want to get too far off topic. When I was doing some research on the Elections Clause, which gives states control over the time, place, and manner of federal elections, I was reading the Federalist Papers, and James Madison mentioned that the expectation was that a lot of this would take place in the context of the state constitution, not through ordinary state statutes. So not only voter qualification standards, but other election rules would happen through the state constitutional mechanism and not just ordinary statutes. So we do a lot of it by ordinary statutes, but that seems contrary to the initial expectations.
Well, that's super interesting for two reasons, and then I'm going to let Atiba back in. But number one, I'm still here. I do want to distinguish between votes that are cast after election day and votes that are received after election.
Right, absolutely.
Because I think there's a big difference. I do think we have a pretty strong norm against the idea that people get to vote a couple of days later.
Of course.
But votes being received after election day is very different. And I would note, many of the people listening are in Idaho and probably can relate to this, but you're in California, you probably have a bunch of central post offices and mail moves pretty quickly. Here in Wisconsin, every piece of mail has to go either to Milwaukee or to Minneapolis, St. Paul before it comes back. So if I mail something to my across the street neighbor, or more to the point, to my municipal clerk, it has to go to Milwaukee, get processed, and come back. So things can take a little bit of time.
So let me throw something else into this mix, which is the fact that over recent history, as you pointed out, Fernita, and in my experience of living in Wisconsin for 2 years now, given this focus on the ability for states to run elections and the sort of center of gravity given to them by design, coupled with the sort of partisan motivations for this sort of thing, right? I mean, a lot of the criticism in the press is about this election in and of itself was, hey, look, the Republicans see an advantage for pushing through with this election, and so the opinion that you see coming out of the Wisconsin Supreme Court, where it was in essence a 4-2 Republican versus Democrat decision, was, and just looking at the state sort of political ideology issues and the legislature. I mean, I was reading some stuff put out by the Democratic members of the Wisconsin Election Commission who were talking about this is about the Republicans seeing an advantage for instituting disenfranchisement through this, sort of special space within the Federalist constitutional scheme for the ability to run elections. And I think that, I think this question necessarily has to get added into this mix, in part because, and I mean, correct me if I'm wrong, but I don't see another way to read it, at least on that level, sort of the political advantage and kind of which makes me think about looking forward and doing better, that we need, broader senses of reform that take the partisanship out of these sorts of considerations. I mean,
Yeah.
I realize I'm ranting a little bit here.
No,
but,
no. I definitely want to second that, Atiba. I couldn't agree with you more. In part because now this is one of the reasons why I've been meaning to get back into this literature about whether, like, the demographics that are actually affected by some of these restrictions, these voting restrictions, because we make a lot of assumptions, and partisans also make a lot of assumptions. So I think in Wisconsin it was easy in the sense of, if you look at the areas that had, the least amount of in-person voting places, it was clearly disproportionately, African-American, Latino individuals who were affected, right? And you can make some assumptions about that based on partisanship. You can also say that with respect to, voter ID laws based on which demographics are less likely to have the relevant ID. But I've been thinking about the amount of voters who tend to vote Republican. How many of them are affected, right? Because the thing with voter suppression is that not only does it affect your opponents, it also affects some of your voters. And one example that came to mind is the North Dakota voter ID law. There were a disproportionate amount of Native Americans who were affected by that restriction, but there were a whole lot of white people. Right. And so it just made me wonder if the end game is to try to suppress the vote so that your opponents don't turn out, to what extent are they also harming themselves, and how will this really work as a long-term tactic if you are also suppressing your own votes? And so, and I don't know the answer to that, but it just strikes me as a technique that won't work for the long term.
Well, Fernita, just note. Sorry, I was just going to say. Just note, I think this is a really important question that you and Atiba are raising about partisanship. We should have been at the low ebb of that concern here, because Wisconsin's spring election was nonpartisan. The only thing that was on the ballot was the 2 presidential primaries, and the presidential primaries were essentially over by the time we voted. Now, I understand that we had a very contentious state Supreme Court race that people sort of mapped partisanship onto, and there was very clearly a liberal candidate and a conservative candidate, in part because the conservative candidate chose to put his nonpartisan campaign headquarters in the Republican Party of Wisconsin's offices. But this was a nonpartisan election. All of the local offices that are on our spring elections, that's why here in Wisconsin we have spring elections versus fall elections, is that spring elections are nonpartisan. So when, as you say, the partisans seized upon this, both in terms of activism and organization, but also in terms of how the courts reacted, it's really worrisome when we think about what's going to happen when there are elections that truly are partisan.
Mm-hmm.
Yeah, no, I mean, I agree, which is why part of me, because I guess in one sense that reveals the truth, right, of partisanship as a kind of lens through which one sees everything becomes, from a sort of normative perspective, a bad motivating factor for, administrating elections, right? If your premise is, I want my team to win, and therefore I'm going to assume, as Fernita, you were pointing out in your response, I'm going to make these rules that strike the demographics that tend not to want to vote for me. I mean, I think you're right, Fernita, that oftentimes that gets over-inclusive. Mm-hmm. And, in my own research, I have thought a lot about kind of the Jim Crow era and how disenfranchisers of a century ago were perfectly okay when the point was raised, well, we know you want to disenfranchise all those African Americans. They use different names for them back then, but I'm going to keep it polite here. But what about those poor white people?
Right.
They're kind of like, you know what? We're okay with them getting disenfranchised too. And moreover, we'll bring them back in when we need them. And thinking about like Louisiana, for example, being the perfect example. Huey Long didn't like it, those people voting, until he wanted those people voting, and suddenly the rules changed. So, a lot of this is this long history of partisanship and how it correlates with, or how people suppose that it correlates with, sort of race and class and age and all these sorts of things. But then it becomes messy. But I think it's also worth taking a moment, since we're on that topic of partisanship and identity. I teach at Marquette. It's in Milwaukee, Wisconsin. So this election, I was talking with a student of mine today who had voted, and they were telling me the stories about the long lines. And I was looking into what they were saying and looking at the press reports. I think the New York Times had it that where Milwaukee traditionally had about 180 polling places, on election day there were 5 available. And Milwaukee happens to be the biggest city in Wisconsin, as well as the place of the highest concentration of African Americans in the state. And on the call we had Tuesday with lawyers litigating these cases that we're commenting on, at least one of them is in the first motions of filing a suit that raises, among other things, Section 2 Voting Rights Act claims. Given those statistics, and of course the reduction in polling places was largely because and this gets to some of the vulnerabilities of the system. And another meta point to make here is that the pandemic sort of aggravates the cracks in our systems that already exist. So, a lot of these polling places got closed precisely because we'd rely on senior citizen volunteers to run these places, and those folks are the most vulnerable to the pandemic, right? And there was an inability to get protective gear for folks to do in-person voting. And so the people weren't available. And so I think the theory of their case is that because the governmental apparatus chose to go ahead in a circumstance where they knew that these vulnerabilities would disproportionately affect African Americans in Wisconsin, that the VRA was violated. And I think they'll also point to how the neighboring counties that do not have those African American concentrations and who also happen to lean more Republican had lots of polling places open, and it was easy to vote. And this was reported in the New York Times and other places. But it's interesting to see how, and this gets back to the earlier point, right, that to a certain extent, there is this interest in terms of states running election, but as we know, as basic election law theory, there's also interest in avoiding precisely this kind of discrimination. And it's worth observing that these two things clashed on election day,
And then the
anti-discrimination versus, but go ahead, Jeff.
Well, I was going to say the question gets back to the conversation, Fernita, from before, which is what's an election statute at that point? So one of the challenges that was faced in Milwaukee County is, as Atiba notes, that there weren't enough election workers. It takes about 30,000 poll workers to run an election in Wisconsin. And Milwaukee County in particular had a dearth of poll workers that did result in a reduction from 180 polling places to 5. Well, there's a statute in Wisconsin that says that to be a poll worker, you have to live in the county where you're poll working. Is that really an election statute, or is that something that maybe in an emergency we could set aside? Because we had plenty of poll workers here in Madison, right? Madison is a city that's probably less than half the size of Milwaukee, and we had 66 polling locations on election day. And the couple that I walked past, with my mask and such, were pretty much empty. There were more poll workers than there were voters, whereas we all saw those lines in Milwaukee. And there were similar lines in Green Bay, for what it's worth, where we went from 31 polling places typically to 2. And so you've got all of these, there are some things that we know are an election statute: the date of the election, the voter ID requirement, how you get an absentee ballot. But then there are a bunch of things that, certainly I don't think that Mr. Madison, when he was writing the Federalist Papers, would have thought of as election statutes. I can't imagine he would have thought that it should be in the Constitution where your poll workers come from. And yet, maybe the Supreme Court would say that those are election statutes and that the state has to strictly construe them, and that no court can set them aside, even if the statutes didn't have sort of an invidious purpose, but we understand that their application is going to create real problems.
So let me ask this question, and I'm getting some questions from the audience as well. So is what happened in Wisconsin a case of successful voter suppression, where there was a clear choice to respond to the pandemic in a way that would make it easier for people to vote, and the powers that be refused to do that? There were efforts to try to make it easier for people to vote in the courts and through the governor's order, and those efforts failed.
Absolutely.
Now, did it work though? Because was voter turnout higher than expected? But isn't it true that in terms of the election for the Wisconsin Supreme Court seat, that the challenger successfully defeated the incumbent with a higher than expected turnout in that race?
Well, the challenger, Judge Karofsky, did defeat the incumbent. I'm not sure that people really expected her to win. Certainly, I don't think anyone expected her to win by the margins that she won by. So, if we go back to the partisan lens and we say, was this successful? Well, maybe it wasn't, because I think that those running the legislature, who clearly were attempting it in substantial part, a motivation for not moving the election or not playing ball and trying to make it better, was an effort to drive down voter participation because they believed it would help Justice Kelly, who was the incumbent running for re-election on the court. In that sense, it was not successful. They did not get the outcome that they wanted and I think predicted. But we did have fewer voters than we expected. We had a turnout of around 1.3, 1.4 million voters, and I think that the expectation was, with two presidential primaries and a highly contested Supreme Court race, that we were going to see somewhere between 1.7, 1.8, maybe even 2 million voters. And so there was definitely suppression. There were people who didn't get to vote. There were a couple 100,000 people who requested mail-in absentee ballots and didn't return them, whether that's because they didn't receive them, or whether they weren't returned in time, or whether they just didn't. But there were plenty of people, I can tell you, who wanted to vote and were unable.
I think that's how I define successful suppression, is when people want to vote and can't, as opposed to me, it doesn't matter what the outcome is. Even if the more progressive judge would have lost, I would still have the same opinion, because I think part of the problem with our system is that things are not voter focused enough. Because you have partisans running the system, and they do focus on outcomes. They are focused on winning elections. And so, but I don't think we can talk about voter suppression in those terms, because otherwise we get to a sense where we're okay with voter suppression so long as we get the outcome that we wanted. And, I want to shy away from that, because I do think that voter suppression, if the right to vote is fundamental, if we believe that, then we should also try to do better. It's one thing to say the U.S. Supreme Court is saying that there are restraints on the ability of states being forced to do things, right? States being forced to make it easier to vote. But another way of framing that is, should states feel compelled to make it easier to vote if they can, right? And I think the answer to that should be yes, right? I think, as the electorate needs to be more demanding of their elected officials in making access to the franchise easier for people who are legally entitled to vote. But we're not really having a conversation in those terms. It's like, because we're focused on outcome, I think, we focus on the election, we look at the outcome, and then we move on, as opposed to having a long-term conversation about how we can improve our system to make sure that everybody who is supposed to vote can actually cast a ballot.
And I would just add to that, simply that it's so very tempting to use outcome. I mean, it's completely the wrong measure, right? And that feeds into this feedback loop of result-driven kind of partisan, as long as my side wins, everything is okay thinking, which many have argued is precisely why we can't have the conversation that Fernita just suggested we need to desperately have, right? And so I think voter suppression is complete when we have an intentional structuring of elections to make it harder to vote. And clearly the evidence shows that there are people who wanted to vote who could not or would not because of the risk. And even though others might have had the ability to overcome those barriers, that in and of itself doesn't change the calculus here. This was an intentional choice to go forward in a circumstance that was more difficult for voters, and thus preventing access.
So I'm thinking about other states watching what just happened in Wisconsin and making decisions about the extent to which they may adjust, if necessary, election laws in November to make it easier for people to vote. If we need to adjust election laws in November to make it easier for people to vote. And I'm wondering if part of what happened in Wisconsin was there was a backlash, there was a perception that the legislature was, for partisan reasons, trying to make it harder for people to vote. And that led to people trying really hard to be able to vote. And I recognize that there's a lot of people who wanted to vote who were not able to vote. But I'm wondering if there is some sort of backlash phenomenon. Well, and let me ask you this: is the Wisconsin legislature just as likely to act the same way in November?
I think so. I mean, I think the Wisconsin legislature, look, we have the strongest gerrymander in the country. The Republicans get about 47% of the legislative votes, and they hold 63% of the seats. Until and unless that changes, and they have no interest in that changing, I don't think that they are going to continue to act out of partisan interest because they can, and it rewards them. So I do think that there's a public backlash. I think that that's an entirely fair reading of what happened here, and I think it's an entirely fair reading of the conversation that's happening in Wisconsin. That said, whether it actually translates into people changing their votes, whether this becomes the defining issue on which people vote, I think it's exceedingly unlikely. When it becomes time to vote for the legislature in November, I think that's exceedingly unlikely.
Are there other states besides Wisconsin that are taking advantage of the current situation to try to make it harder for people to vote in a way that might support the outcomes that they would like to see?
Correct me wrong on the state, but I think Texas has made it so that people can't use Corona as an excuse to vote absentee. That's one that immediately comes to mind.
I think too, regardless of what's happening in the short term, this is a point too where we can think about November and speculate whether or not the second wave of Corona comes early or late in the fall. I mean, it's one of the things I worry about is whether, if the incidence of the virus and some of the worst case scenarios are a second strong incident of the virus coupled with a particularly bad regular influenza season coincide. And if those things happen early enough in November, I mean, we could see gamesmanship, in the presidential election. And what happens then? I worry about, for the reasons that we've been discussing all hour, states possibly taking advantage of that. I just throw that concern out there. I don't know what you all think.
Well,
yeah, and just adding to that, just some questions we're getting from the audience is, what should we be doing now to try to ensure that something like this doesn't happen in November?
Well, I think one of the things that's ironic is that in some ways, the election that shouldn't have happened 3 weeks ago here in Wisconsin might put Wisconsin in better stead for the fall than some other states. That is to say, a couple of the cases that I mentioned earlier that were filed before the April 7th election are still ongoing, and I think that there's likely to be some additional litigation in the coming weeks. And we have a factual record. We have experiences and anecdotes and plaintiffs to say to courts, hey, look, we need to fix this before our August partisan primary and before our November general election. Because if you wait till the last minute, then we run back into Purcell and where we started. And so this is the time. And we have tools here because we have those facts that some other states don't have, where it's much easier for judges to say, oh, that's all speculative. Oh, you don't know what would happen. Whether and to what extent courts and the legislature are willing to listen to that stuff remains to be seen. But we may well come out of this in Wisconsin slightly better.
I would hope so, as a fellow Wisconsinite, given the record. And, we had that conversation Tuesday, and I think this will be posted on the ACS website as well, so you can see that in detail. There's been a lot of talk about instituting and making preparations for voting by mail now. And that jumps to mind as something practical that we can do. And to the extent that there are statutes that, for example, require some explanation for voting absentee versus, in Wisconsin, a no-fault absentee ballot standard, leaning to those forms of liberalization and building the infrastructure to help states, including states where there are voter ID requirements, even for absentee balloting, that requires thinking through how to do it and putting the infrastructure in place. And so it strikes me that those things can be done now by legislatures and executives who are thinking through the worst case scenario of what November could look like.
I also think that to piggyback on Atiba's point, it takes money too. And the CARES Act, I think, only provided $400 million to the states to deal with some of these election-related issues, and that's not enough money. And so, in order for states to do what is needed, in order to prepare for November and the possibility that many voters will be voting by mail, the federal government needs to allocate more funding.
There's a lot to explore. I mean, I think funding's important. Here in Wisconsin, I mentioned earlier, we have 1,922 different people running elections. We have the most decentralized elections in the country. So we have 1,850 municipalities, each of which runs their own elections, sends out their own absentee ballots. In a big city like Milwaukee or a medium-sized city like Madison, that's done by a professional full-time city clerk who has a staff. But in a lot of our small towns, the town clerk is a part-time volunteer position, and you're relying on somebody to assemble and send out those absentee ballots, after they get home from work. There are tremendous numbers of challenges, even in moving to by mail voting. And I know that there are states that have successfully done it, but my understanding, at least here in Wisconsin, is we have people with disabilities who cannot vote by mail. They need assistive technology and they need a place to be able to go. We actually have pretty good statutes allowing people who are itinerant and people who are illiterate or who don't read in English to get assistance at the polls so that they can vote. And those are people who are not going to be served by a vote by mail system. So there's a tremendous amount of complexity to work through, and it takes money, but it also takes political will. I think that the money is a real issue, but at least in some states, Wisconsin being an example, I think the political will is the much greater challenge right now.
If we move significantly towards vote by mail in November, where a lot of states shift, and that's a predominant method, particularly in a bunch of swing states, is it likely that we won't know the outcome of the presidential election on election night because we're going to be counting ballots that might be arriving after election day or several days after election day?
Yes, and that has to be that has to be okay. I can't
right.
emphasize that enough. That has to be okay.
Right. And so this goes back to your point about norms, right? This goes back to your point about norms. I think that a lot of people are just used to finding out the results of the election on election night, and to think that there's something wrong if they don't know the results on election night. And if they see vote totals change in the 2 or 3 day period after election night as more mail-in voting comes in, then that undermines their perception of how legitimate the election is. They think that there's something weird going on because we're not used to, as a country, relying on vote by mail and having kind of extended periods where you might be counting mail-in ballots that are coming in. There was recently this report on fair elections during a crisis by this ad hoc group that was chaired by Rick Hassan. And they have a bunch of different suggestions. Some of them are legal changes, but some of them are proposed changes in terms of norms and in terms of the way that the media covers the election in November in 2020, where you don't necessarily declare a winner on election night if you have a very significant number of ballots that have been mailed in that have not yet been counted.
I think that has to become the new normal, because if you think back to Iowa in January, which seems like it was 5 years ago, even though it was only a few months ago, there was some mishandling by the Iowa Democratic Party, but there was also this, message in the media where it was just like, well, something's wrong because we don't know who won. It's like a horse race. There has to be a winner, and we really have to get past that mentality, because when people vote by mail, it takes longer. Right. And so, we have to go into November understanding that we might not know who won on election night. And that does not necessarily indicate some type of malfeasance. But I don't know how well people will internalize that message, given the fact that, the president has a Twitter account.
Well, and here in Wisconsin,
and the president.
Go ahead.
I was just going to piggyback really briefly and say, and the president has been openly slamming vote by mail. Mm-hmm. And sort of, in some ways, setting partisanship aside, this is one of those things that could be done now on the state level, explaining that the new normal is going to require these things to happen. And yes, it might be a week before you learn the result in a particular state, but that's got to be okay, because asking people to risk death or illness is the alternative, and that's unacceptable. If we can agree on that, then all these other things hopefully would flow logically. But that's a lot of hope.
That is a lot of hope. I would also just note that, I think that a major piece here is how long does it take for the ballots to come in. But I know, at least under Wisconsin law, counting a ballot that arrives by mail is simply a much more arduous task. I know that sounds silly, but when you go in and you vote and you feed it into the electronic vote counter, at the end of the night, they stick a thumb drive into the electronic vote counter and it tells them, what the vote totals were. When they get a ballot by mail, they have to check the envelope. They have to make sure that the witness signature is correct. They have to make sure that the person's signature matches what's in the poll book. They have to check all of these things, and they have to open the ballot. That takes time, and you have to fish the ballot out, and you have to make sure that it's correctly filled out so that you can feed it into the machine. And if the machine kicks it back out, you might have to remake the ballot. These are all things that when people vote in person, they sort of get taken care of at the time. Someone on the elections commission, one of the elections commissioners, told me that on average, it takes 10 times as long to count an absentee mail-in ballot as it does to count a regular ballot. And that means that even if all of the votes are received on election day, results might take an extra few hours, an extra day or two.
Is it possible that results? Sorry, Atiba, please go ahead.
Oh, I was just going to briefly say that a lot of the conversation has evoked the sort of what I like to call the meme of voter fraud about voting by mail. But the story Jeff just told about ensuring the reliability and security of ballots is an important part of what has to be told in terms of the vote by mail case, because all those steps are designed precisely to, ensure election integrity. And I think that's a point to be underscored.
Yeah, so I'm just thinking in terms of perceptions of integrity and legitimacy. It sounds like vote by mail might just take longer to do. Is it also possible that there might be more disputation of vote counts when you have vote by mail? And then we might have more situations where there are election contests or requests for recounts in different jurisdictions in 2020, in November 2020. And if so, seeing how the federal courts responded to the situation in Wisconsin, how does that make you feel about how the federal courts might respond to litigation related to the presidential election in 2020?
Can I speak to the first part of your question? Because I do think that one thing we can't assume is that vote by mail doesn't have its own unique problems, right? So people of color have their mail-in ballots rejected at a higher rate than white people. And so there has to be some safeguards put in place to ensure that legitimate votes are counted and not just discarded. And there also, that system also has its own unique security concerns. But if states start planning now, these are things that could be addressed as long as we have enough lead time to get it in place for November. So, no one is sort of proceeding with this assumption that vote by mail is the perfect solution to these problems. I think that in November, there has to be some mix of vote by mail with in-person voting to accommodate voters who, as Jeff mentioned, can't vote by mail. And so as long as there's some type of hybrid system, I think that we'll be fine, but we do have to start now.
And are we concerned about litigation in November 2020 and how the federal courts might handle that?
Well, I think there's a concern about litigation, but I almost want to say that the concern existed in an alternative universe where there were no pandemic. I would still be worried about election litigation, given this whole partisan rift that we are reading all this through to begin with. I think that just as a general matter, and this is sort of the outcome of Bush v. Gore from, the politics of elections point of view, that, election law litigation has become a tool in certain circumstances for partisans who feel they can game that system if their margins are close enough. So I would be concerned regardless of the format. The litigation may look different because the concerns would be different in a hybrid vote by mail and in-person system, but the litigation risk is heightened, and it's been heightened, and it will just be that way. And it has been for, as I'm arguing, the last 20 years.
I agree with Atiba. I would suggest that I think it's getting worse. But I think we've reached a point, unfortunately, where litigation is just part of our election process. It's just, there are lots of stages of elections. And I think we need to get used to the idea that in close and important in terms of the election results, not important in some grand theoretical sense, states, litigation is just a substantial part of the context. It's really good for business for me, but I think it's terrible for our democracy. I mean, I agree with what Fernita said earlier, which is the goal is not outcomes. The goal is that everybody gets to vote, and that we promote democracy, and we have the strongest country we can have in the sense of people participating, being engaged, and having those opportunities. And so I think in this sense, the litigation is not necessarily helpful. I think it lots of it's trying to be helpful, and lots of it's seeking outcomes that would be helpful. But I do think that it contributes to an overall sense of there they go again.
So we blew past an hour because time flies when you're talking about potential constitutional dystopias. So I will invite each panelist to provide brief concluding remarks. And in the short time that you have, could you just tell us, just how do we solve all of these problems completely? And short of that, is there anything that you want to leave our audience with in terms of the most important thing that you want to end on?
Wow.
You don't have to solve the entire thing. But
solve it in 30 seconds.
But a message to leave our audience with.
I'll go first.
I'll jump. Oh, go ahead.
Yeah. Well,
nope.
I was going to say, I think it's important for for people to think through these things, and I think that one of the real lessons is whatever state or jurisdiction or place you're in, whatever place it is that you decide you care about and you want to help make sure that elections run as smoothly as possible. Understand just how complicated elections are and how many people are involved, and really spend some time learning how they work and who those people are, because there's a tremendous amount that can be done through informal advocacy and without litigation. And if you're going to go the litigation route, it is tremendously important that that you do so with real knowledge and understanding, because the fastest thing that makes a court discount your argument and your claim and what you're trying to accomplish is when you show up and can't speak comprehensively about what's going on. So I would encourage everyone to be involved. This is a growing and vitally important area of law, but pick a place, pick your issue. There is so much to be done, and a lot of good work for all of us.
Thank you. Atiba?
So I think that the conversation we've had today points out the fact that there are weaknesses in our electoral system, in our voting system, that have been exacerbated by COVID-19. And I think that paying attention to these underlying questions of making the system voter friendly, in this sense that we have been talking about it, and making sure that the right balance is being struck between policies designed to maintain the integrity of elections and policies that are designed to make sure that every voter who wishes to vote can vote and do so in a safe way. I think that striking that balance has to be the ultimate goal that we're looking to in terms of getting to that big picture solution. But to tag to what something Jeff said, don't fall for the myths and the suppositions about what is or is not good for us, because these questions of integrity and access can often be shaped by partisan motivations, and those motivations can tag to other forms of concern. But if we are a republic that wishes to have a robust democratic practice through the craft of voting, we have to look to that balance and make that balance our goal.
So I guess I'll end by saying that when we tell people to vote as if their lives depended on it, we don't literally mean their lives should depend on it, right? Like, we don't want people to endanger their lives in order to vote. And so I guess my message would be, for November, vote as if your life depends on it. But if the state tries to make your life depend on it, sue their asses.
I think that's the perfect note to end on. So thank you so much
to
all our panelists.
We need a microphone to drop.
Thank you so much, everyone, for doing this. I really appreciate it, and we all appreciate it. So keep up the good work.
Thank you for having us.
Yeah, thanks. This was a great conversation, guys.
Thanks, Danielle.
Thanks, Ben.
This is fantastic.
All right.
Very well. Thanks a lot.